Hello friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the Election Commission's order on reducing the Sikkim Chief Minister's disqualification period. So let us first see what is the current affair. When we analyze the current affair, we will see that the Election Commission has reduced the period of disqualification from electoral contest of Sikkim Chief Minister Prem Singh Thamang to 1 year and a month. So 1 year, 1 month is the disqualification period. Now, when we talk about the Election Commission's mandate is to conduct free and fair elections in the country. And under this duty or under this function of the Election Commission, there are broader implications or broader functions. It means that the democracy which is based on the principle of elections, periodic elections conducted by the Election Commission. So Election Commission is responsible for the conduct of free and fair elections in the country and to ensure that the democratic values and principles are reflected in the elections. So the recent incident is that the Election Commission reduced the disqualification period. Now, what is meant by disqualification? When a candidate or when a person is not fit for elections, the Election Commission will disqualify the person from contesting the election. So, Election Commission has reduced the period of disqualification for the Chief Minister of Sikkim and it was reduced to 1 year and 1 month. So, this is the current affair, but towards the end of this lecture, you will get a clear idea about the functions and duties of Election Commission, the involvement of the judiciary in this and what really happened and is this justified and all that we will understand. And this is a very, very important topic from the UPSC perspective, especially from your mains examination perspective. Now, for your prelims examination, what is more important? More important is the Election Commission as a constitutional body and also the mandate, duties of Election Commission, etc. But from your mains examination, you need to analyze the current affair and you need to interpret the current affair. You should be able to give your own suggestions. So this is what we will be trying to cover in this lecture. So let us first understand the story. What was the charge against the Sikkim Chief Minister Prem Singh Thamang? Now, Mr. Thamang was convicted under the Prevention of Corruption Act. Now, the Prevention of Corruption Act aims at eliminating corruption and thereby ensuring transparency and accountability of the government machinery. Now, the charge was the misappropriation of 9.5 lakh in the purchase of milch cows for distribution in the year 1996-97. So this happened long back in 1996-97 and the amount involved in the corruption case was 9.5 lakh. Now, 1 year prison term had been given to him and this 1 year prison term was upheld by both the High Court and the Supreme Court. And he went to the jail and he was released in the month of August 2018. Now, after that what happened? After August 2018, after he was released from the jail, he was controversially appointed as the Chief Minister. Why controversially? This is because he was imprisoned for 1 year term for a corruption case. So he was imprisoned and charged under the Prevention of Corruption Act. So his appointment as the Chief Minister had become controversial. So he was appointed as the Chief Minister of Sikkim by the Governor of Sikkim in the year 2019. Regarding the appointment as the Chief Minister, Mr. Thamang did not contest the election. He did not contest election, but he was elected as the legislature party leader by the SKM. This is the party. This is Sikkim Krantikari Morcha. This is the party and the party had elected him as the legislature party leader. And the SKM party had won the election. So, according to the constitutional provisions, when we talk about the state legislation, the political party which wins the election, the leader of the political party will be appointed as the Chief Minister by the concerned governor. And on the recommendation of the Chief Minister, the governor will appoint the other ministers. This is the constitutional provision regarding state legislature. Now, when we talk about the union legislature, the Prime Minister shall be appointed by the President of the country and the president appoints the leader of the party that has won the election, or the majority party that won the election, as the prime minister. It can be also the leader of the coalition. So, and based on the recommendations of the prime minister, the other ministers shall be appointed by the president. So this is the constitutional provision regarding state legislature and union legislature. Now the governor of Sikkim appointed him as the chief minister because he was the leader of the SKM party which had won the election. Now, why this is more controversial? This is because this is against the Supreme Court ruling in 2001. Now, let us see what is the Supreme Court ruling in 2001. The Supreme Court in the year 2001 had issued a ruling, and this was in the case of late Tamil Nadu Chief Minister, former Chief Minister Ms. Jayalalitha. And in this statement, the Supreme Court nullified the appointment of late Ms. Jayalalitha's appointment as the Chief Minister in 2001 due to her conviction in the year 2000 in Tansi. Tansi is a Tamil Nadu Small Industries Corporation case. So, in this case, she was convicted for a corruption case in 2000, and that is why in 2001 Supreme Court had nullified her appointment as the Chief Minister. And in this case also, Tamang's appointment as Chief Minister was challenged in the Supreme Court. Now let us come to Tamang's response. Now, Tamang approached the Election Commission of India, the ECI, for removing his disqualification. Now, on what basis did he approach the Election Commission of India for removing the disqualification? First, in the 2003 amendment to the Prevention of Corruption Act, that is POCA, Prevention of Corruption Act, which was amended in 2003. According to the amendment in 2003, any conviction under the anti-corruption law would attract a 6-year term disqualification. Now, Tamang argued that the law prevailing at the time of his offence, that is, we have seen that the offence committed by Tamang was in 1996 and 97. But the Prevention of Corruption Act was amended in 2003, and according to the 2003 amendment, the term for disqualification is 6 years. But the incident happened in 1996-97. So what does it mean? It means that the 2003 amendment is not applicable to the Tamang's case. Now, what was the law that was existing in 1996-97 when the offence was committed? So, Tamang argued that the law prevailing at the time of his offence entailed disqualification from contesting election only if the sentence period was for at least 2 years. But we have seen that he was imprisoned only for 1 year. So, after 1 year imprisonment, he was released from the jail. So, according to 1996-97 law that was existing, that is the time at which this offence happened, disqualification would only be applied if the conviction is for more than 2 years. So that is why he had approached the Election Commission for removal of the disqualification. So this clearly means that 2003 amendment does not apply in his case because the law was not in place when this corruption case happened. Now, let us come to the decision of the Election Commission. Now, the decision of Election Commission under Section 11 of the Representation of People Act of 1951, RPA, which is Representation of People Act, a very important legislation for your UPSC examination. According to RPA 1951, the Election Commission has the power to remove or reduce the disqualification attached to a conviction. So, Election Commission has got powers in concurrence with the Representation of People Act. Now, the Election Commission's current order is that Mr. Tamang is eligible to contest a by-election and retain his post. So, this is the present decision of the Election Commission. So, this is very important. RPA, Representation of People Act, and the duties and powers of the Election Commission, very, very important for your UPSC examination. Now, let us see why there is a controversy, why this is considered as a wrong precedent. First thing is that the Election Commission has got wide powers and duties under the RPA of 1951, Representation of People's Act 1951. But the Election Commission has used the powers under RPA only rarely. That means the Election Commission does not always use its powers under RPA, Representation of People Act, and only in very rare cases involving conviction for corruption, the Election Commission uses its powers. So this is the first thing that makes it controversial. Why the Election Commission is not acting upon its responsibilities on its powers. Now, second one, disqualification from contesting the elections. This is a civil disability, and this is created by electoral law to keep those convicted by criminal courts from entering the elected offices. So, disqualification is just a civil disability. Now, what does this disqualification mean, or why such a provision has been created? This is to decriminalize the politics, the political system in India, to keep those convicted of criminal offences from entering the elected offices. So those who are convicted of corruption offences, they should not enter the politics or should not enter elected offices. So that is the rationale behind the disqualification provision, which is a civil disability. It is not a second punishment after a criminal sense. So, suppose the court convicts a person. This is the punishment given by the court, the Indian judiciary. So, this is the punishment, and disqualification should not be considered as a second punishment which is optional. It should be considered as a response of the Election Commission towards the court's conviction. So, this is just to keep those who are convicted away from the elected offices. So, this is the second thing. Now, third one, if we consider disqualification as a civil disability and not as a second punishment, then the arguments of Mr. Thamang cannot be supported, cannot be justified. And thirdly, this affects the Election Commission's credibility. This is because recently there were many legislative actions. Bills were presented in the parliament, also judicial measures. The Supreme Court itself had commented on decriminalization of politics. So, even though there were many recent legislative and judicial actions against corruption and also for decriminalization of politics, the Election Commission's decision to allow Mr. Thamang to contest a by-election and to retain the post is highly controversial. Judiciary and the legislature is trying its best to strengthen the framework, the legal framework against the corruption. So it is morally wrong. Now, when we talk about decriminalization of politics, the present action of the Election Commission is against the decriminalization of politics. And it also clearly shows how the Election Commission is biased towards certain political parties or certain politicians. Now, what is the way forward? When we talk about the apex court, the Supreme Court has described corruption as a serious problem, and a serious problem that is damaging the democratic principles of the country. And now when we talk about the legislature, the parliament has also recently taken steps to decriminalize politics. So the way forward is that the disqualification provision should be strictly applied, and this is within the purview of the Election Commission under the Representation of People's Act. So the Election Commission should rightly comply with the provisions of RPA, the Representation of People's Act, and should strictly apply the disqualification provision. This will help to decriminalize the political system in India. You can find the PDF of this lecture on our website www.studyiq.com. You can also follow my Facebook page for more video updates. You can write to me at joyce.studyiq@gmail.com for any of your queries and clarification. Thank you.